My name is Jess Johnson. I'm an attorney at the law firm Johnson Citronberg based out of Alexandria, Virginia. And today I want to talk about internet sting operations and the related Virginia offense called solicitation of a minor. Most of these internet sting operations are conducted by officers who are part of the ICAC task force. And ICAC stands for Internet Crimes Against Children. And that is a federally funded program around the country where state police officers pose as minors online, trying to lure people in to get them to talk dirty to them, to send them pictures, and to meet up with them for sex. Now, ICAC is a federally funded program, and what that means is that the number of dollars that ICAC gets is largely dependent on the number of arrests that they make. And for that reason, they're going to try to arrest as many people as possible. Now, these officers are going to go undercover, and they go onto a social media platform or a dating application, something like Facebook or Snapchat or Grindr, whatever it might be, and they'll create a fake profile. And from there, they'll wait for someone to reach out and contact them. Now, once someone contacts them early on in that conversation, they're going to tell the person that they're a minor, that they're either 14 or 13 years old. And we'll talk about that age in a second. But they'll tell the person that they're a minor. Then the conversation usually takes a bit of a turn, and it's going to take on a sexual tone. And this officer is going to try to lead that person down a path where they're talking about sex. Now, the person will usually get arrested, either at the point that they send a dirty picture of themselves and their genitals, or, in the alternative, at the point that they agree to meet the minor out somewhere. Now, when the person is arrested, they're normally charged with the offense of solicitation of a minor. There are really 5 elements to the offense of solicitation of a minor, and I'm going to walk through them one by one. The first element is that the person was 18 years or older at the time of the offense. The second element is that the person used a communication system like a cell phone or a computer to carry out the offense. The third element is that the person did so with the purpose of soliciting with lascivious intent. The fourth element is that the person knew or had reason to believe they were communicating with a child younger than 15 years of age. And finally, there is a fifth element, and that fifth element can occur in a variety of ways. There are actually 4 different ways. The first way is by exposing your genitals to the child. The second way is by asking the child to expose his or her genitals. The third way is by asking the child to perform some sexual act. And finally, the fourth way is by enticing or inviting the child somewhere to commit a sexual act. If the person who's been convicted of solicitation of a minor had reason to believe that the person was less than 15 years old, and the person himself is 7 years or more older than the child, then that person is going to face a sentencing of somewhere between 5 to 30 years. And that 5 years is a mandatory minimum sentence that the person will have to serve if they're convicted of that offense. Now, this is a pretty harsh sentencing scheme when we're talking about a mandatory minimum. And this is why law enforcement will say in those chats that they are either 14 or 13 years old usually. Because if they say that they're 15 or 16 or 17, you're talking about a less severe potential penalty. I now want to shift gears and talk about defenses in these cases. A lot of people think that there are no defenses, that these cases are indefensible. And that is simply not true. In just about every case, there is a viable defense that you can put forward. And we start really with ICAC itself. If we go back to the Internet Crimes Against Children's Task Force, they have their own rules and regulations. And you would be surprised the number of times that their officers violate their own rules and regulations for how they engage with people online. And the whole purpose of these rules and regulations is to make sure that someone isn't entrapped and that the person actually believes that they're talking to a minor. And so a real starting point here is to check out these rules and to see how law enforcement may have violated their own set of rules. We also routinely run into this situation where the person who's arrested thought that they were talking to an adult. And so what we have to do is look at all of the surrounding circumstances. And this means that we have to do a number of things. We have to look at the platform and the application that was used. Many of them are only for people that are 18 or older. So it's quite reasonable to believe that if you're on an app that only allows 18-year-olds and older, that you're not going to be talking to a child. Another thing that we often look for are the photographs that law enforcement used. During their internet sting operation, when they're talking with the user, they're normally going to send that person some kind of photograph. The photograph is usually going to be the actual officer who's gone undercover or it's going to be a photograph of another law enforcement officer who has agreed to have their picture used. Now, clearly, these are pictures of adults, and so what they will do is they'll airbrush the picture to make it look like they're a bit younger. We also have to look at their profile that they used online. In a lot of cases, the undercover officer is going to put that they're 18 or older. And so that's strong evidence that the person didn't know that they were talking to a supposed minor. Law enforcement also loves to target people who are in role play or fantasy chat groups, something along those lines. To the person who's arrested, this was all a mere fantasy and role play, but law enforcement is going to use that to their advantage and get an arrest if they can. It's also a common tactic that we see that law enforcement only tells you their age early on in the conversation. Another tactic is that they may engage in multiple chats over multiple days or weeks or even months. And so it's very difficult for a person to remember what this user may have told them 3 weeks ago or a week ago after many different chats. Another good defense in these cases is going to be the defense of entrapment. Now, to show entrapment, you really have to be able to demonstrate two things. One is that law enforcement induced you to commit the crime. And second, you have to be able to show that you were not predisposed to commit the crime in the first place. So this means that the idea to commit the crime had to have come from law enforcement, and you have to be able to show that you never would have done this without some kind of pressure or coercion from law enforcement. And again, this is where we go back to the ICAC manual and guidelines setting out exactly what officers are supposed to do and not do in these cases. Now, one thing that sets our firm apart from other law firms who handle these cases is that we don't just rely on entrapment or arguing that they didn't follow guidelines. We like to go on the attack with our own credible witnesses, and there are a few different types of witnesses that we like to use. The first type is going to be an expert witness, and there are really two expert witnesses that we use in this case. The first is going to be a clinical psychologist who can conduct what's called a psychosexual evaluation. And these evaluations will say that our client has no sexual interest in children whatsoever, which is powerful evidence that rebuts the Commonwealth's theory that our client was trying to have sex with a child. The second type of expert that we use is going to be a computer forensic expert. And a computer forensic expert can look at our client's cell phones and laptops and desktops to see if there's any history there of them being attracted to children or talking to children in the past. And usually we're going to find that our client had no history or interest in children whatsoever. Again, powerful evidence that rebuts the Commonwealth's theory. Finally, there's another class of witnesses, and that's going to be the character witness. And a character witness in this type of case is normally going to be an ex-wife or an ex-girlfriend or current wife or girlfriend, somebody who has intimate knowledge about your likes and dislikes, or somebody that knows you very personally, can talk about your private life. And if we can have that kind of witness come in and say, look, I know this person and he has never expressed any interest in children whatsoever, that too can be powerful evidence to rebut the state's case. Again, my name is Jess Johnson. I'm an attorney at the law firm Johnson Citronberg. We handle these cases across Virginia, and we've done so for many years successfully. If you or someone you know have been charged with solicitation of a minor or a similar offense, give our law firm a call. We're happy to listen and we're happy to help.